we're clear, a bench conference on a stipulated order to modify the bond condition to allow the defendant to go to work. As I was indicating, given the argument that was being made and everything, it seemed a little bit odd to me, and I wasn't going to sign it until I got some clarification regarding it. But I think I have it. The defendant has insisted because the bus route, which I didn't know what, I don't know what bus route is what, but he just explained that that's the bus that runs from basically outside of the courthouse down to the 777 building. So, all right, then I will sign that order. Let's see.
Thanks.
All right, I got it. Okay, thank you, Honor.
Thank you. Right there.
Court does call the case People versus Hannah Smith Seeley.
APA Richmond, Deputy for the People.
Your Honor, good morning. Joe Simon appearing by Zoom for Ms. Smith Seeley.
Lisa. Oh, I'm sorry, Mr. Simon. Hi.
Hello, Your Honor. We switched the time and your staff was gracious enough to allow me to appear by Zoom so that I could make it.
Yes, sir. All right, what are we doing on this case?
Your Honor, the parties have reached a resolution of the case. You should have a plea form in front of you. However, there's a couple things to update the court on. That my client had a single instance of a scram tether violation. She's been on since May 27, 2025. On one date, that being July 12, 2025, she had numbers. Community Corrections asked my client to report everything she did that day because she insists she did not consume alcohol. The only thing that she could report was that the landlord had an industrial service, or not, I mean, a service come in and do carpet cleaning. She has a toddler that's 1 year old, a toddler that she plays with them on the floor. That's the only explanation she could offer. Community Corrections did not think that that was accurate, and that's how we're here. The people have, excuse me, my client was screened and accepted into the 15th District Court Sobriety Court. Ms. Johns of the Sobriety Court is aware of this violation. She will still take my client. My client still wants to go to Sobriety Court. And if we can resolve the plea today, as indicated on the plea form, by the way, I forgot to check the guilty box on that form. That's my error. I apologize. We asked the court to allow that to happen. And I told Ms. Johns that court runs on Fridays, as the court may know, the 15th District Court Sobriety Court. When I originally, this was on the 3 o'clock block, I told Ms. Johns that by the time my client, if your court released my client, that by the time she got tethered again, she would never be available for Friday. But now that we're on the 9 o'clock block, that could happen. And if the court allowed that privilege, I'll do what I can to make that work out.
So she would be appearing at the sobriety court tomorrow morning, you're indicating?
Well, she won't be officially accepted until there's a sentencing. But
right.
I'm sorry, that's not true. She's accepted, but she won't be a part.
You can feel it under the polished wood, behind the paperwork. It's not law that drives these trials. It's ego, fear, revenge, and hope, all tangled into one ticking moment. Every glance is a calculation. Every word is a weapon. This isn't justice. It's war in slow motion.
Participant officially until she's sentenced, but I think Ms. Johns would want her there tomorrow if she was able to be there tomorrow, and my client would go tomorrow.
Okay. Any response from the people on that? All right. So I've checked the guilty box, also the sentencing judge waiver, because this is not my case, but I presume you went through that with her. Mr.
I did,
Simon.
Your Honor.
All right. May I have her sworn?
Rich, you solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Lower your hand and say, and then spell out your name.
Hannah Smith Seeley.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating with a high BAC second offense. Is that correct?
Yes, Your Honor.
All right. That's a misdemeanor punishable by up to a fine of $1,000, 5 days to 1 year in jail. The court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
I should also advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before a judge. Hello?
More.
Who was my 15th district court judge?
Judge Moore does the sobriety court.
Judge Perry. Well, we have to do it by the numbers. This is a Perry case? Yes. All right. You'll be sentenced before Judge Perry in the 15th district court. You understand that, ma'am?
Yes, Your Honor.
All right. And so to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
You have any questions regarding any of those rights?
No, Your Honor.
You'll see on the podium, I need you to look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
As soon as I can find my paperwork. Yeah. On July 31st, 2024, at the location of Washtenaw Avenue near East Stadium Boulevard in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consumed intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
I had a substantial amount, Your Honor.
Okay. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I
Your Honor, my client was badly injured. She doesn't really know. Her car struck a pole. That's really why she can't quantify the alcohol. You'll hear in a minute that the BAC by blood was 0.336.
So you know that you hit a pole. All right.
Yes, Your Honor.
But all right.
The law loves logic, evidence, statutes, precedent. But when the lights dim and the cameras stop rolling, cases don't run on logic, they run on instinct. You can't measure guilt, you can't quantify remorse, and you can't predict what fear makes people do. You can only watch and feel.
So at some point, ma'am, you're not going to dispute you're taken to the hospital, correct?
Yes, Your Honor.
All right. And at that point, there was a blood test. You're also not disputing that.
No, Your Honor.
And you're not disputing the right of the police to take you to the hospital and have a blood test taken,
No.
correct?
Correct.
All right. And the results of that blood test, as your counsel has indicated, is 0.336.
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Had you previously been convicted of operating while intoxicated on or about April 16, 2014 in the 14B District Court of operating while intoxicated and or operating while impaired on or about December 1st, 2022 in the 14B District?
Yes, Your Honor.
All right. Ma'am, I do have to advise you, because there at least is an agreement regarding sobriety court in this case, that if you were to commit misconduct between the time of my acceptance of your plea and the time of your sentencing, that first of all, you would not be permitted to withdraw your plea, and secondly, that any sentence evaluation or recommendation the court would no longer be bound by. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I know about the people.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. I'll set sentencing in this case, and you guys can work around what you'd like to work around, but sentencing,
Sentencing will be August 28th at 8:30 a.m.
August 28th, 2025, 8:30 before Judge Perry. That's the time that we have. With reference to bond, any response from the people?
Your Honor, I just want to make sure I'm clear. Counsel is requesting her to be released on PR bond in the hopes that she can be seen at 15 tomorrow.
No, no.
Well,
I'm
he
sorry.
wants her bond reinstated,
Yes.
which means she would have to go back on a tether. And then the hopes is that she'll be out. She would attend at least something regarding the sobriety court tomorrow, although not officially participating.
Yeah,
But
and I'm just going to try to make that happen. I can't guarantee that it will, but yes, she's already attended and observed. But I know that after this disposition, I will inform Ms. Johns, and if it can happen, I'm pretty confident she'll want her to observe again.
I understand. The people, quite frankly, don't buy the explanation regarding the reason for the scram tether violation. But I also understand that due to the circumstances of her transferring, we don't necessarily need to hold a whole hearing about it, essentially. So the people defer to the court. I am certainly requesting that her bond be reinstated with that scram tether.
Can I say something?
pardon?
Can I say something?
Want to say something? Go ahead.
I still have the tether on.
You
Oh.
still have a tether on.
Yes.
I made a wrongful assumption. Well, that makes things a little bit easier. I'll notify Ms. Johns right away.
All right. What time is sobriety court?
He usually
8
runs
a.m.
8 a.m.
When a judge speaks, the words echo far beyond that room. They follow the guilty into prison cells, the innocent into therapy, and the lawyers into sleepless nights. Every sentence isn't just a decision, it's a haunting. Because justice doesn't end when the gavel falls, it lingers.
What I will do is I will grant the defendant's motion, reinstate her previous bond, but that reinstatement of her previous bond will not take effect until 12:01 a.m. on 8/8/2025, since she already has the tether on.
So, Your Honor, I'm just, if that means that she'll be held through 12:01 a.m. tomorrow, correct?
Correct. She
did.
can then get herself somehow down to Ann Arbor by 8 if she's going to attend that session.
Okay. That would be a little more difficult. We'll try to make that happen.
It shouldn't be difficult. She can walk to Ann Arbor by that time.
Thank you, Your Honor.
I know you could, and you're much older than she is.
Well, not
So-
not at present, but thank you, Your Honor.
Okay. All right. Thank you. No. Well, no, because I'm reinstating the tether. So we may need a new just tether order. So that they're clear. But she already has it on. Court calls the case People versus James Belleville.
Families on behalf of the people.
Good morning, Your Honor. Edward Drukas on behalf of James Belleville, who should be appearing on Zoom. Could you unmute Mr. Belleville?
Yeah, I'm unmuted.
Okay, state your name, sir.
James Michael Belleville.
All right, go ahead.
Thank you, Your Honor. I'm asking for about a 3-week adjournment pursuant to what's in our green sheet.
Probable cause conference, August 28th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the People versus Sheena Stout.
Assistant Public Defender Chelsea Virgils with and on behalf of Sheena Stout.
Your name, ma'am?
Sheila F. Stout.
All right, what are we doing?
Your Honor, we are asking for an adjournment in this case. I'm also asking to briefly address bond.
We have a green sheet. Probable cause conference in this case will be adjourned to August 28th, 2025, 9 a.m. Yes, as to Bob.
Your Honor, Ms. Stout expressed to me desire to seek substance abuse treatment. I believe that the prosecution may stipulate to that. I can have a stipend order presented to the court later today. So we're just asking for the court to allow her release to inpatient treatment.
I will always allow release to inpatient treatment. Just send me the order. I'll sign off on it.
Okay, thank you, Your Honor.
Bond will continue. Thank you. Court calls the case, People versus Taylor Adams.
Your Honor, we can cook the people.
Annie Mack on behalf of Mr. Adams, who is to my right. Please state your name for the record.
Taylor Adams. I have a question, Your Honor, if that's okay.
You have a question
For you, if that's okay.
for me?
Yes. What are my charges on this case?
Yeah. What are they?
What are they? Yeah.
You don't recall them from arraignment or?
No, I just wanted to make sure. I was told that it was malicious. It's not attempted. And I want to make sure that it's attempted. That's what I was charged with was,
Okay.
legend.
You have two charges.
Yep.
That allege that on or about December 6, 2024, location of Sibley Road in Sylvan Township. Count one is attempted malicious destruction of fire or police property.
Attempted.
That's the 2-year offense.
Yep.
Then the second charge is reckless use of a firearm or weapon. That's a 90-day, $500 fine. Those are the two charges of that.
Already attempted. Thank you, Your Honor.
Thank you.
Your Honor, requesting to adjourn this matter.
Without objection, probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thanks, sir.
Those people. Court does call the case of the People versus Adonis Sweat.
On behalf of the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Adonis Sweat.
Adonis Sweat.
Okay. You would like the same adjournment to the 11th?
Yes, Judge. The prosecutor just informed me that there's more that he was made aware of yesterday, more discovery.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. The court does. Court does call the case of People versus Trayvon Addison.
Your Honor, we can cook the people.
Annie Mack on behalf of Mr. Addison, who is approaching. Please state your name for the record.
James Trayvon Addison.
Your Honor, we request to set this matter for preliminary examination and all discovery is complete, as far as you're aware.
People have their witnesses available on the 19th.
We'll do our best, Your Honor. Thank you.
Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge.
12 noon with you.
12 noon, that's before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Shaquille O'Neal Tubbs.
Good morning. I'm Rob Jekyll on behalf of Mr. Tubbs. Judge, in this matter,
State your name, please.
I'm sorry.
Shaquille O'Neal Tubbs.
Thank you.
This is Judge, Mr. Ken Overwater from the PD office has him in recovery court. I talked to Ms. Sample. she says if we can waive him up to circuit court, he will be
He can
eligible for
get
the
that.
recovery court.
Okay.
Is that your signature and X? Okay.
Right.
There's a waiver, Judge, properly signed,
I've
but
seen Mr. Tubbs for I don't know how long. I'll tell you if it's his. Yep, that's it. Sir, you're waiving your right to a preliminary examination.
Yes, sir.
You understand a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right, people also waive their right. Preliminary examination haven't been waived, defendants bound over on the single count.
as far as the information, Judge will waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
August 21st at 1:30 with Judge Slay.
August 21st, 2025, 1:30 before Judge Slay.
We'll probably be in recovery court.
Well,
Oh, yes.
Well, I gotta know.
Oh, okay, hold on. We're gonna go to, gotta go over, get to recovery court.
Okay.
Okay? All right, thanks.
Bond will continue. Good luck, Mr. Tufts. Court calls case People versus Seth Anderson.
Good morning again, Your Honor. Assistant Under Dodgy Leba on behalf of Mr. Anderson, who's approaching. Mr. Anderson, can you state your name, sir?
Seth Anderson.
And Your Honor, today we're going to be requesting an adjournment. We've discussed a potential offer to the prosecutor. They've indicated that they'd need some more time to decide on that, and my client's indicated he'd like some time to consider that as well.
August 28, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Sean Belledew.
Thank you, Richard. For people.
Edward Drix on behalf of Sean Billady.
Name, sir? I have before me two plea forms. Is that what we're doing today?
Yes, Your Honor.
They both indicate that in each case he'll be pleading to an added count two of larceny, 200 to 1,000. He'll be pleading no contest. Needs the 1 year offenses. Upon a successful plea to that charge count, one would be dismissed. There is no other agreement.
That's our understanding.
It's the court's full understanding. Is that the people's understanding?
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so you got. Lower your hand and then state your name.
Sean Lauren Plotkovich.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to, or no contest to, two charges of larceny, 200 to 1,000. Those are misdemeanors, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is subject matter to theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in these cases, and you would be sentenced before Judge.
Yes, Your Honor.
Before Judge Valvo and Perry. Which one's Valvo?
Judge Valvo.
Do you understand what a no contest plea is, sir?
Yes, sir.
All right. Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand these
Yes.
charges?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. So, sir, to the charge of larceny 200 to 1,000 contained in the case ending in 5670. He's already signed sentencing judge waivers. I don't,
Yes, Your Honor.
just trying to get the offense date on this. I have my they filed. Get these files this way. in 5670 occurring on July 10th, 2024. How do you plead?
No contest.
To that same charge contained in the case 5615 occurring crazy. I'm sorry, sir. I don't know why they have this file done in this way. Really? Where's my complaint?